Hi everyone, I'm Eric Rodebois. This is EPGD, Attorneys at Law PA, coming at you from Coral Gables, Florida, right in the heart of Miami. As you know, we probably told you, we opened up an office in Washington, D.C., which is kind of my roots. My mother's from there, and I got my law degree and started my career there. And so today's a story from Miami, actually. A client of ours had an employee, and the employee quit, okay? Turns out the employee didn't only quit, the employee and her husband went and opened up their own business doing exactly the same thing. Now the good news for my client is that they had the foresight a couple years ago to ask all of their employees to sign a non-compete agreement. It's actually an employment agreement, employment contract, and in the employment contract it'll say things like this is at will, this is your salary, your benefits, what we're going to give you. And also, if you quit and for a period of 2 years, you can't enter into a competing business, whether owning it, working for it, being affiliated with it, etc. And so this company happens to do web design, search engine optimization, etc. And they're great at it, by the way. And so this person quits and she starts her own competing business, and they have direct proof of it. Like there's no question. So they come to me and they said, Eric, what did we do? And I said, well, did you have an employment contract? And they said, yes, we did. And I said, do you have a signed copy? They go, of course. And so they send it to me and I'm looking through it. And first of all, I can tell I didn't draft it. Every attorney has their own style. Some people have their own fonts. You know, for many, many, many years, I was New Times Roman. I was single-spaced. I always indented the beginning of any new paragraph. I knew my style. I had an extra space between any two paragraphs. I would always do the initials on the bottom. Like there's just a certain way that I know when I look at a contract, I'm like, oh, that's one of mine. And so I'm looking at it, and sure enough, there's no attorney's fee clause. I can't find the attorney's fee clause. Okay, so let's talk what that really means. The American rule says that if you sue somebody, you have to bear your own costs. And even if you win, your cost of representation is your burden. So you can go out and hire a $200 an hour attorney or a $600 an hour attorney. It's your choice if you can afford it, and at the end of the day, that's what you pay for. Well, the exception to the American rule is if there's a contract or a statute that awards attorney's fees. Some statutes will say if you violate this statute, it creates a civil cause of action and person A can sue person B, and if they win, the statute will allow them to receive reasonable attorney's fees. Those are great. We're always looking for those statutes. In fact, in this story, there is a Florida Trade Secrets Act. So if we can show that this person was stealing their trade secrets, we might be able to get attorney's fees under the Trade Secrets Act. That's great. But how much easier would it have been in this 7-page employment contract that this person signed 4 years ago on their first day of work, which, by the way, Florida is fully employer-friendly. It allows the employers to impose employment contracts. I make all of my employees sign employment contracts. It's just good practice. And Florida will allow the employer to impose restrictive covenants, non-competes, non-disclosure, non-disparagement, non-interference, etc., etc. And so right there, somewhere towards the end, you have a line, and it says, the prevailing party shall be entitled to reasonable fees and costs. 11 words, okay? Right now, we are defending one of these. We are representing the employee who's being sued for breaching a non-compete. We are at $65,000 of attorney's fees on our side, not the other side. We are at 2 years. It was filed in September of 2016. And we are set for trial in a month, and it's very easy that somebody could ask for a continuance, so it could easily be another 2 or 3 months. Now, the good news is we're pretty much done litigating. We're just waiting, so my client's not going to receive many more bills. But the point is, we haven't even gone to trial yet. Trial could be easily a $15,000 in fees, like preparing for trial and doing a trial. $15,000 to $20,000 even. Okay, so now let's go back in time. My client has a employment contract that it looks like they downloaded off the internet. And if they paid a lawyer for that employment contract, I'm advising my client to sue that lawyer for malpractice, because I would have charged that client $1,000 to prepare an employment contract template that they could use for all of their employees, and it would have an attorney's fee clause. So now my client says, well, what's the deal? And I said, listen, I need a $5,000 evergreen retainer, and there's no cap, and it could last a month or it could last 3 years. I'm really sorry, I can't predict the future, and that's the situation. So for all of you out in EPGD land, make sure that you're not downloading contracts off the internet, and if you are, make sure you're making sure that they have an attorney's fee clause. Thank you so much. I'll talk to you soon.